Hello, everyone, and welcome to the CLRC webinar, Empower Hour, 5 Legal Tips for People with Cancer. So first of all, let's talk about what the CLRC is. The CLRC stands for the Cancer Legal Resource Center. We are a program of the Disability Rights Legal Center. The CLRC provides information and resources to people affected by cancer, including patients, survivors, caregivers, and healthcare professionals. Our resources are free, regardless of income. This presentation is intended to give general information and is not intended as legal advice. This webinar also does not establish an attorney-client relationship. There will be time for Q&A after the presentation. I also welcome questions during the presentation if they would be beneficial for the group. One last thing. I also want to say that I hope to be able to answer your questions, but there may be instances I might have to tell you I don't know it, either because it's not information I have offhand or it might be too specific for today. However, I encourage you to fill out an intake with us so we can properly research the information. People often ask, what does cancer have to do with the law? This is a list of some of the cancer-related legal issues. Cancer affects the patient, survivor, families, healthcare professionals, and impacts many different areas of the law. If someone has a legal question and is affected by cancer, whether or not the topic is listed here, they can contact the CLRC for more information. This is the first webinar as part of the Empower Hour series. As you can see on your screen, we have a lot of other exciting webinars coming up. I hope you'll sign up for all of them, and this is really great because you can listen to them out of order afterwards. It'll be on our YouTube page, but I hope you join us live because there's a certain level of immediacy and these are really important issues. So why wait any longer to listen to them? An important thing to note is that the webinar series, the Empower Hour series, is supported by a grant from the Tower Cancer Research Foundation and a grant from CGen. So we are so grateful for their support. The CLRC also has a professional panel, which includes attorneys from across the country who help those with cancer if a caller needs help with a matter in their state and public area. You saw on the previous slide the practice areas that attorneys handle, but just to recap some of them: landlord-tenant, health insurance matters, medical malpractice, estate planning, employment law, and divorce law. It's a minimal commitment. All the attorney agrees to is a half-hour consultation. It's very easy to apply. We hope that you'll join us. That I put the link on your screen to sign up for next week's event. Even if you're not a lawyer, you can still learn more about our professional panel and learn about top 10 ways to get health insurance claims paid for people with cancer. But certainly if you are a lawyer or know a lawyer, please share that information. We'd love for as many people to join us. If you would like to view our resources on any number of topics related to cancer, please visit our website. Educational webinars like this one are recorded, so we can later put them on our YouTube channel for you to share with anyone who may want to learn more about a variety of topics. And also, this is important because we cover a lot of ground in this and in the other webinars. And you don't have to write everything down or remember everything 100%. If there's a specific part that you would like to refer back to after this presentation, you can look at the YouTube video later on after it's posted on the YouTube website and go to the specific part and pause it there, write something down. So the great part is you can pay attention, soak up as much as you can, but you don't have to feel like you have to remember everything. If you have questions about today's presentation, please type them in the chat box. I will be leaving time at the end to answer some questions, and that part of the presentation will not be recorded. However, if you have questions about your specific situation or someone you know has a question you want to ask about, please fill out our online intake form at CLRC intake.org, as you can see on your screen. After you do so, we can research laws and resources for you and provide you with free customized resources. Everything is confidential. With the generous support of the American Cancer Society and Breakaway from Cancer, the CLRC has a revised version of the Patient Legal Handbook. This handbook provides an introduction to the most common legal issues that a patient diagnosed with cancer is likely to face. It is available to download for free online in English or Spanish by going onto our website, theclrc.org. Providers can request printed copies shipped to their offices. If you have an oncologist or if you know an oncologist, you can also tell them about our patient legal handbook, and maybe they could order it so all the patients can have access to this free guide. So I'm not keeping any secrets from you. I'm going to share these 5 legal tips right at the beginning so you know what I'm going to talk about. And then we'll go in greater detail so you can feel very confident that you know these 5 legal tips. It's not a surprise. I want to make sure you have them right at your fingertips. Number 1, it is the patient's responsibility to understand his or her insurance coverage. Number 2, don't take no for an answer. Number 3, request accommodations before your work performance is affected. Number 4, you may be able to take time off and keep your job. Number 5, document your end of life wishes before it is necessary. And one of the reasons why I wanted to call this series Empower Hour is because at the end of every hour, you will be, whether you feel it or not, you will already be more empowered with knowledge that even if it's not specifically helpful at this very moment, may be crucial for you to have in the future. And after all, you may not even realize it, but it is incredibly helpful. So let's get to tip number 1. It is the patient's responsibility to understand his or her insurance coverage. We recognize that it is an impossible task for some patients, but it is unfortunately how the law is set up. That means you have to read the fine print. People make the mistake in thinking doctors, surgeons, nurses, etc. treating us have to know what's covered by our insurance plans and what isn't, or to what extent. Even if they say they will call the insurance company to find out, it's always a good idea for patients to become familiar with their plans so that they understand their copays, deductibles, and networks. This helps prevent unforeseen costs. You can find it online if your company offers an online portal, or ask your human resources for a copy of the policy if you get insurance through your work, or a summary of coverage notice when you first buy your plan. Read the fine print. There are some laws that require insurance plans to cover certain services, regardless if it's spelled out in the policy. So I'll go over that information here shortly. Of course, having insurance in the first place is one huge step toward addressing practical financial concerns. One or more of the following options may be available to you. I won't go into a lot of detail about these different options, but suffice it to say that you should be aware of your insurance options. We have additional resources available on our website. Employer-sponsored or COBRA. This may be an option if you are leaving your job or you have lost your job. It is expensive, but it can help maintain coverage after employment. An alternative and potentially less expensive option would be to purchase a new plan through the state marketplace. Some states have their own private marketplace, while others use healthcare.gov. It may be tempting to buy the cheapest plan, the one with the lowest monthly cost, but some of those plans with lower premiums may end up costing you more in the long run if they have higher deductibles or higher out-of-pocket costs. When you enter your income on the website, you'll learn whether there are tax credits to help you lower the cost of your insurance premiums each month. The same is true for short-term health plans. They may be cheaper, but they likely don't provide the coverage that someone would need if they get diagnosed with cancer. Medicaid is a health coverage program run by the states. Eligibility traditionally based on low income, low assets, low disability, or rather disability. Some states have expanded eligibility to just income. Medicare is available to people who are turning 65 or who have been eligible for SSDI. That stands for Social Security Disability Insurance for 24 months. The most important thing I will mention about Medicare is that we hear far too frequently from people who opt not to sign up for Medicare when they first become eligible due to already having other coverage or believing that the card was sent to them in error. If you are nearing Medicare eligibility, either age or SSDI, please make sure that you fully comprehend potential downfalls of not signing up during the initial enrollment period. It can lead to severe penalties. For example, every year following the eligibility period that someone does not sign up for Medicare Part B, they incur a permanent 10% penalty added onto their premiums. So if someone delays for 2 years, they will have to pay 20% more per premium permanently. However, these penalties don't apply if someone meets conditions that allow them to sign up during a special enrollment period. Here are some resources. I'm going to pause for a moment because we are the Cancer Legal Resource Center. So we do provide resources. We highly recommend the Medicare Rights Center and the State Health Insurance Assistance Program. For additional Medicare resources, you can contact our office through our online intake as well. Also, check the requirements and eligibility if your state has a health insurance premium payment program. I will not be discussing the specific prescription drug options available, but feel free to reach out to the HICAP office. If you're looking to purchase insurance through your state's marketplace or healthcare.gov, we are getting to a critically important time of year in the fall. So we do actually a special health insurance and open enrollment webinar. So don't worry, we'll take care of you in terms of information. So it's important to keep in mind that you can only purchase or change plans during open enrollment or if you're eligible for a special enrollment period. Now, this was a little bit different as a result of the pandemic. There were a little bit different opportunities to sign up, but now after the pandemic, protections are easing up, then this is more and more important to remember that around the fall in 2022, it does vary by state, but that's on your screen is the rough date, so you can have that in mind. And some states have their own private online marketplace while others use healthcare.gov. In the next slide, I'm just going to show by way of example. A lot of times the information for signing up is not updated at this point. So I thought it might be helpful just for a frame of reference to see how it was this past year in terms of respective dates. This is a national webinar, so we have people from across the country that are listening and watching. So it's just important to keep in mind that you, even if you're happy with your health insurance, you may want to explore other options and to know that time framework. And also, if you are exploring other options, take the time to research whether your doctor or doctors, if you're satisfied with them, and the treatments that you have are covered by any other possible health insurance options that you're considering. So if you can't get health care otherwise, here are some options. Private health insurance. Although this can be an expensive option, anyone can purchase private health coverage as long as they do so directly from an insurance company or through an insurance broker. Some people are not eligible to purchase through the marketplace due to immigration status or Medicare and Medicaid eligibility. Hill-Burton, that's a congressional law which gave hospitals and other health facilities money for construction and modernization. In return, the facilities that received these funds agreed to provide a reasonable volume of service to people unable to pay. The program stopped providing funds in 1997, but about 140 healthcare facilities nationwide are still obligated to provide free or reduced cost care. So that's really important to know. You can call the national hotline to get a list of obligated facilities. Charity care. Many hospitals have free or low-cost care available to low-income patients. Speak with a social worker, financial navigator, or the patient services at your local hospital department to determine what options may be available. You'll often have to provide information about your income and other assets. If you are insured but are concerned about outstanding medical bills or the best ways to use your insurance coverage, these tips can be helpful. Here are a couple things to keep in mind to make sure you get the most out of your insurance policy. You can check with the insurance company to see if they offer a case manager. If your plan or hospital does not offer a case manager or patient navigators, ask to speak with the same person each time you call, if possible. Positive rapport can go a long way, as the insurance employees may be willing to spend time finding ways to reduce costs. It's the hospital case manager that makes sure a patient's health insurance company understands what's happening during the patient's hospitalization. They make sure the insurer has all the information and needs to, and it's important to really um, be familiar with this, because the hospital case manager communicates with the health insurer's case manager every day or every few days. And a hospital case manager might negotiate coverage benefits between a health insurer provider and the patient. The health insurance company's case manager receives information from hospital case managers, home healthcare companies, physicians' offices, social workers, and other healthcare providers. It can be awkward to have conversations about costs with your providers, but at the end of the day, if you can't afford the treatments and prescriptions your provider is recommending, or aren't adhering to the scheduled dosing because of cost, your provider needs to know. They can't help or recommend less expensive options if they don't know your situation. Keep dates, times, and extension numbers in addition to writing down names. If you're required to get pre-authorization, request it sent by mail or email and keep it. If you fail to get required prior authorization for a certain service, it can be difficult to get the service approved later. Open all mail, even if it seems daunting. Review all bills. Compare them with your explanation of benefits, or EOBs. Insurance EOBs explain what you owe the provider. Mistakes happen. I'll talk a little more about billing errors and medical billing later in this presentation. CLRC tip number 2. Don't take no for an answer. This is a life tip, but specifically a cancer legal tip in the area of health insurance denials and disability insurance denials. I'll talk about how it applies to health insurance denials and Social Security applications. If you're denied coverage of a health insurance benefit, you should not take no for an answer. Appeal. Private insurance companies have different procedures for appeals. I'll explain your rights here as it relates to private insurance. If you have Medicaid or Medicare, the procedures are different. For those with private insurance, the process for completing the appeal should be found in the denial letter sent by the insurance company, and should also contain information about the strict timelines that must be followed for a successful appeal. I think this is really important, because if you're getting either via email or by mail your denial letter, I completely understand the instinct to just throw it away. But what's really important is, after you see the denial letter, keep reading, even if you don't want to, because the letter must say the procedures for the appeal, as I said, the timelines and what needs to be done. So actually that very letter that you don't want to look at anymore could be the key to actually getting something approved eventually. Often medical teams are unaware of insurance difficulties that patients face. Sometimes it's helpful to bring an insurance problem to the attention of your doctor's office and have them call your insurance to explain why a procedure is medically necessary. They can either help you appeal or help you go another route, so you don't suffer with so much out-of-pocket expense. Many pharmacies partnered with oncologists are able to advocate for insurance coverage as well, and have people on staff to facilitate getting coverage for patients. If you do appeal to your insurance company and they still deny you at appeals, once you exhaust your options with the external company, you have the right to an external appeal. An independent medical review or external appeal is an opportunity to have someone besides the health insurance company decide whether the company should pay for the service you are requesting. In California, HMOs and Blue PPOs go to the Department of Managed Care. Other insurance goes to the Department of Insurance unless it is self-funded, in which case the plan must contract with an independent third party. Usually you have to exhaust the internal appeals process before you can move forward with an external appeal. So that is not true if the situation is urgent. And sometimes in the case of cancer treatment, it is very urgent. According to the Department of Managed Healthcare, in 68% of the cases, the health plan's denial of service was overturned and the enrollee got the requested medical treatment. Once the case has been decided, the health plan must authorize the services in 5 business days. The IMR is easy, and that's independent medical review, is free, easy, and fast. In most cases, the independent medical review or IMR is decided within 30 days of receiving all required documentation. If you need more local one-on-one assistance in filling out the IMR form, please contact DMHC or the DMHC's Consumer Assistance Program, Health Consumer Alliance, at 888-804-3536. I would just want to note that appeal rights might be available to those on Medi-Cal managed care plans, but if you're on Medicare or fee-for-service Medi-Cal, appeal rights are different. Medications must first be approved by the Food and Drug Administration, FDA. Until a drug is approved, it normally cannot be legally given to anyone except through an approved clinical trial or a manufacturer's compassionate use program approved by the FDA. Compassionate use programs allow a manufacturer to give certain individuals a medication that is being tested in clinical trials before the FDA has made a decision about approving or not approving the drug. When the FDA approves a drug, it is approved for certain conditions or indications on the label. Regardless of what the label says, a physician can legally prescribe an FDA-approved drug for any reason. This is called prescribing the drug off-label. Note that your insurance company still may not approve the coverage just because your doctor approves it for your use. And I just want to mention, I briefly mentioned clinical trials. You can see that on your screen. One of the Empower Hour webinars will be about clinical trials. I think that that's such an exciting topic and also very helpful for you just to become more empowered to know the information about. So each plan has a formulary or list of approved medications. Formulary medications can usually be prescribed without pre-authorization. The insurance company, not your physician, decides what is on their formulary. Every drug company has a patient assistance company you can contact to gain access to medication. PAF, or Patient Assistance Foundations, are generally based around diagnosis and have a pot of money you can use and spend down through the year. Another place you don't take no for an answer is with Social Security. Before I talk about denial, I'll just introduce the benefits really quickly. The Social Security Administration is in charge of 2 federal benefit programs, SSDI and SSI. They have the same definition of disability. You must be unable to work due to a severe medical condition that is expected to last at least 1 year or to result in death. SSI, that you see that on your screen, it stands for Supplemental Security Income, is based on assets and income, not work history. SSDI, which you can also see on your screen, Social Security Disability Insurance, is based on work history. One must have earned 40 work credits, including at least 20 over the last 10 years. A work credit is currently defined as earning $1,510 in wages or self-employment income. 4 work credits can be accrued per year. Younger patients have lower requirements. After 2 years of receiving SSDI, if under 65, you'd be eligible to receive Medicare. Make sure your doctor knows that you're applying. They will know what SSA looks for, that's the Social Security Administration looks for, and will make sure to take appropriate notes that accurately reflect your inability to work. List multiple conditions. If a person has multiple things contributing to their inability to work beyond cancer, they should list them all. The Compassionate Allowances Program contains a list of medical conditions that allow for review in days as opposed to months. At the end of this presentation, there will be a link. If your condition falls on this link, you would have to write in compassionate allowances somewhere on the application for benefits. There unfortunately isn't a checkbox, and if you're applying for SSDI, there is still a 5-month wait period. Your application will just be reviewed sooner if you qualify for compassionate allowances review. Many people apply for benefits through SSA, and unfortunately, less than 50% of initial applications are approved. After appealing, the approval rate jumps to about 75%. The CLRC tip is to appeal rather than reapply. We say don't take no for an answer and appeal instead of reapply. And that's because you can be entitled to retroactive benefits. Payments may be retroactive back to the date your disability began, up to 12 months prior to your date of application. If an applicant reapplies, they will lose any retroactive payments. For those who weren't aware, SSDI benefits, if approved, are not payable for the first 5 months of disability. The Social Security appeals process has multiple levels, and there are very specific deadlines to appeal the SSA's decisions. Usually you have 60 days, but pay attention to any paperwork you receive if you're applying for benefits. The steps in appealing are: number 1, the request for reconsideration. Number 2, a hearing by an administrative law judge. Number 3, review by the appeals council, and all the way up to number 4, federal court review. It usually doesn't necessarily need to get that far, but just for you to know all the steps. In some cases, hiring an attorney to assist you with your case may be the best course of action. Lawyers will take fees out of back pay. This SSA has raised the statutory fee cap in fee agreement cases to $6,000. Lawyers can't take more than that in helping someone with an appeal. Again, don't take no for an answer. If you want help filing an appeal, you can hire a private lawyer or legal aid. Contact the CLRC for legal resources. CLRC tip number 3, we are getting through these. Request accommodations before your work performance is affected. We get a huge number of questions about employment issues, so I want to cover some employment laws here. It is your responsibility to let your employer know you need help doing your job if you are unable to do so because of a disability, and notify your employer before your work performance suffers. The American with Disabilities Act, that's the ADA, and your state fair employment agency work together to prohibit discrimination against people with disabilities, which can include cancer. But it's not illegal to fire someone whose work performance is suffering. So that's why we added this tip here. If an employee is not performing the essential functions of their job and their employer doesn't know about their need for accommodations, he or she can be terminated. Having cancer does not always prevent someone from being fired. I'll explain the ADA and what protections people with cancer do have in the workplace. So the ADA is a federal anti-discrimination law. It includes everything from the application to the interview. The ADA applies to state and local governments and applies to private employers with 15 or more employees. The ADA protects employees against discrimination if the employee qualifies for protection. There are 2 parts to this. Number 1, an employee must have a qualifying disability, which the ADA defines as a physical or mental impairment that substantially limits a major life activity. Every disability law has its own definition of disability, so know what qualifies someone for protections under the law. Under the ADA, Cancer can be a disability based on this definition. Number 2, the employee is only protected if the person is a qualified employee. Qualified means that the person can perform the essential functions of his or her job with or without reasonable accommodations. The essential functions of a person's job vary depending on the nature of the work. As an example, an essential function of a delivery person, such as from UPS, would be lifting over 10 pounds. An office worker might have to lift 10 pounds, but that probably isn't an essential function of the job. If there's no reasonable accommodation that would help someone do the essential functions of their job, then the employee isn't qualified for protection. If there's some accommodation the employer can give to the employee to help them do the essential functions of their job, then the employee is qualified. So if you are a qualified employee and your employer is required to abide by the ADA, that gives you certain protections. You can then not be fired because of your disability, and you are entitled to reasonable accommodation, which I'll explain in a second. Just to clarify, people with disabilities can still be fired, just not because of a disability. If someone's performance suffers at work, or they are late or sleeping at their desk, or if someone's company does budget cuts, employees can still be let go, even if they have cancer or another disability. It's a common misconception we hear about, but this is why we added the tip about requesting accommodations before your work is affected. Let me go on and I'll make this clear. The ADA applies to state and local governments and applies to private employers with more than 15 employees. I mentioned that. I mentioned that if you're a qualified employee with a disability as defined under the ADA, you are entitled to a reasonable accommodation. A reasonable accommodation is a change in the work environment that enables an individual to perform their job. A change in the physical environment or a change in policy is, for example, there's no one-size-fits-all accommodation. The accommodation must be reasonable, meeting the individual's needs without being an undue hardship for the employer. So the way to think about it is that it's reasonable for both parties. For example, if an employee has a standing job like a cashier, but has a disability where they can't stand for long periods of time, it might be reasonable for the employee to ask for a chair where they can take sitting breaks. This isn't asking a lot of the employer and helps the employee. That is reasonable. Or if it's reasonable, an employee can ask to work from home or modify their schedule to make it to appointments. Reasonable is a case-by-case determination based on the circumstances of both the employee and the employer. The employee should notify the employer right away if he or she thinks that there's a need for a reasonable accommodation. Let's say the employee has a condition that requires them to take more frequent bathroom breaks and just starts taking them. It might mean a little less work gets done or they are less available. The employer could think that the employee is slacking off. However, if an employee is asked for more frequent breaks to accommodate a disability, then the employee is protected from negative action taken by the employer. This is why we suggest asking for an accommodation before it affects work performance. Just to give an example, although this is a national webinar, I'm just giving an example of sometimes how state laws can be, can add additional support. So the California Fair and Employment and Housing Act, it's an example of California going beyond federal law to protect its citizens. It prohibits discrimination in all employment practices against qualified individuals with disabilities who can perform the essential functions of the job with or without reasonable accommodations. Basically, it provides the same protections that the ADA does, but it is more inclusive. If a patient is not covered under ADA because the employer has less than 15 employees, they are not out of luck. It applies to employers with 5 or more employees. So that's rather than 15 or more. The ADA says substantial limitation on a major life activity, while California's FEHA is broader and only says limitation on a major life activity. So under the ADA, cancer and the effects of cancer of treatment can be a disability, but under the FEHA, cancer is specifically listed as a disability. So whatever state you're in, it's worth it to see, does your state law offer you even more protection? It won't offer less. So it could be the same or more. If you suspect discrimination in employment, we would suggest you contact an employment law or labor law attorney right away to discuss whether it makes sense to file a complaint with the DFEH, with the EEOC, or file a lawsuit. If you're a member of a union, contact a labor law attorney. Um, some people may be covered by both the ADA and state fair employment law. Before you file a complaint, check with an attorney. We recommend speaking with an attorney because in some cases, a lawyer might think you have a good case for a lawsuit, or a lawyer can advise you with what agency is the right agency to file with. So it's a good idea to get some guidance before you make a decision on what action to take. CLRC tip number 4. You may be able to take time off and keep your job. We get a huge number of questions about employment issues. Although laws like the American with Disabilities Act and the California Fair Employment and Housing Act, that's the FEHA, prohibit discrimination against people with disabilities, which includes people with cancer, employers are not prohibited from taking negative employment actions against someone if their work performance is suffering or they aren't performing the essential functions of their job and their employer doesn't know about their need for accommodations. It's generally the responsibility of the employee to ask for changes to the work environment, such as accommodations, before their work suffers. So let's take a little bit of a look at the Family and Medical Leave Act, FMLA. It is unpaid and it provides 12 weeks, which can be taken intermittently or all at once. You must meet the eligibility criteria, and the 12 work weeks of unpaid leave can occur during any 12-month period. And the most important part to remember, yes, while it is unpaid, that your job and health insurance benefits are protected. FMLA is a federal law that gives you the right to take time off with continued health benefits to take care of yourself or a covered family member for up to 12 weeks. FMLA is not a form of income. You can take FMLA if you are the one who needs to take medical leave or to care for a child, spouse, or parent. Not all employers have to provide FMLA leave, however, so it's important that we go over this. Government, local, state, and federal employees do, as well as private employers if there are 50 or more employees in a 75-mile radius. Now, you might be saying to yourself, oh, I work at a Starbucks and there's only 15 people that work here. Well, in most cities or most areas even, there's more than one Starbucks in that area within a 75-mile radius. So if, for example, you work at a Starbucks and there's another Starbucks up the street and then another Starbucks somewhere else within 75 miles and then another Starbucks within 75 miles and maybe even another Starbucks, then you would be covered even though your particular Starbucks where you work has fewer than 50 employees. This is where a lot of people run into issues because unless you work for a large enough company or business, FMLA might not help you. You can take advantage of FMLA if you've worked 12 months, and that doesn't need to all be consecutive. If you worked 6 months one year and 6 months in the next year, as long as it adds up to 12 months, that's fine. And you have to have worked 1,250 hours in the past year. That averages out to about 24 hours a week. So if you're part-time, you may qualify. While on FMLA leave, you are on unpaid leave. But in some circumstances, an employer may require, and the employee has the right to choose, to use accrued vacation or pay time off so that they get paid while on FMLA leave. Or an employer may require, and the employee has the right to choose, to use sick leave when the leave is for the employee's own serious health condition. So let's say you have 3 weeks of vacation accrued and 1 week of sick time, and you're eligible for FMLA, you most likely will not get 16 weeks from work. Most employers would require the use of sick and vacation time leave concurrently with FMLA, which means that the 12 weeks of unpaid FMLA leave would turn into 4 weeks of paid leave due to the use of sick and vacation time, and then the rest of the time would be unpaid. Now, what if you don't have enough time off? So it can definitely be a situation where someone has had surgery and needs more time to recover, or there is a recurrence after treatment, or it's just the treatment itself takes a harder toll or needs to go longer in order for someone to be done with that treatment. So, and in some cases, the person is not qualified for FMLA. So we first say to check your employer's policy and also to consider to request time off as an accommodation under the ADA or state law. And as you can see, the information that we've learned so far today about the ADA is applicable, which is why we talked about it before. It can potentially apply to this situation. It's important to know that the FMLA can work alongside the ADA. For example, if you took 12 weeks of FMLA leave but were not ready to return to work, additional leave may be granted as a reasonable accommodation under the ADA. However, courts have held that the ADA generally does not prevent workers from erratic, unplanned absences and whose accommodations involve being absent from work. To be protected under the ADA, you must be able to perform the essential functions of the job. If attendance is an essential function of the job, then one cannot be protected under the ADA. In other words, courts have ruled that attendance is a basic job requirement. For example, if you're a surgeon, then attendance may be an essential function of the job. It's hard to telecommute in for a surgery. So if you're asking for additional leave beyond the FMLA, it can only be a reasonable accommodation when there's a definite end to the leave and when the employee's absence does not pose undue hardship on the employer. So you might be eligible for the 12 weeks and then have a doctor's note that says you need to take an additional 5 days off for recovery. That extension may be treated as a reasonable accommodation. But if you tell your employer that you need more time off, but that you aren't sure about when you'll be able to come back in, they'll probably say that it's an undue hardship to keep your position open indefinitely and deny the accommodation. For example, one of our callers worked for a large company with a very generous leave policy. After 2 years, she was finally going to be terminated and inquired whether her employer could actually do this. Unfortunately, no employer is required to hold someone's job open indefinitely, and after 2 years of medical leave, it likely wouldn't have been reasonable to ask for another extension of medical leave. CLRC tip number 5. This is the last tip. No matter what a person's health, it's important to make future plans for your health and property and do so before it's necessary. People should not wait until they are sick or at the end of their life to do advanced planning. Although it's better to do it later than never. So it could be a really difficult topic to discuss, but for everyone, no one lives forever, even Betty White. So it's important to remember that documenting your wishes helps your wishes live on after you do. And that can actually be very empowering. So you can put something down and then kind of put it to the side and not think about it anymore. And if you write it and you want to change it, you can still do so. It's not written in stone, it's just written in paper. Even if you think that everyone, friends and family knows what you want, if it's not in writing, then it may not be sufficient and could leave your friends and family in a difficult situation of trying to figure out what to do. You're the only one who knows your true beliefs and desires, down to what you want to happen if you cannot care for yourself. This is true when it comes to decisions about healthcare as well as decisions about dividing up your property. I'll discuss some common advanced planning tools here in the next slides. The key to advanced planning is to do it in advance before someone becomes incapacitated or their judgment may be called into question by medications or illness. Advanced planning can be broken up into two parts, one that focuses on property and the other that focuses on healthcare. We're all somewhat familiar with wills, but there are formalities that need to be followed to ensure that a will is valid. For example, and I'm just using California as an example, because I know we are a national webinar, so we have people from all across the country. Wills can be constructed in 3 different ways in California. They can be prepared by an attorney and signed by witnesses. This is usually the preferred format to ensure the will meets all requirements. A person can fill out a statutory form from the California Bar website if they do not have complex assets. Additionally, a caller can handwrite, sign, and date a will. If the will is not created with the assistance of an attorney, it is best to have it reviewed by an attorney to ensure that it is valid. A trust is an arrangement whereby one person, called a trustee, holds legal title to property for another person, called a beneficiary. There are many types of trusts. You can create them separately while you are alive, a living trust, or through your will, a testamentary trust. The main advantage of a living trust is that it avoids having a family having to go through probate court after a death, which can be expensive. One very basic tool for advanced planning is a will. A will is a document where you basically lay out who you want your property to go to, but there are formalities to create a valid will. The rules about what constitutes a will are determined according to state law, so it is important to consult local resources or call us at the CLRC to find out how to create a valid will in your state. There are generally three ways to create a will: a holographic will, your state statutory will, or number three, have your will prepared by a lawyer. So in California, a person can write a will purely in their own handwriting as long as it's all handwritten and signed and dated. It can be recognized as valid even without witnesses. This is called a holographic will. Some states recognize holographic wills. California is one of them. A statutory will is one in which you fill out your state's statutory form and have it signed by two witnesses and notarized. Another way to create your will is to hire an attorney. A qualified estate planning attorney can make sure that your will conforms to state law, whether you want the attorney to draft a will for you or just review one you've prepared for another method. The attorney can also offer suggestions that help you understand the many ways that property can be transferred, which may be economical in the long run for you and your beneficiaries. CLRC has referrals to some attorneys who might be able to help, including legal aid organizations in certain locations. A trust is an arrangement where someone, you, the grantor, settlor, trustor, transfers legal trust title to property into a trust for the benefit of another person, a beneficiary. The creator of the trust names a trustee who will manage the property and distribute it for the benefit of another person, the beneficiary. There are different types of trust. The most common is a living trust. This is created to go into effect during the grantor's lifetime. The grantor can name themselves the trustee and retain ownership and control of assets during his or her lifetime, and name someone the successor trustee to manage assets upon your death. It can be more expensive to set up initially, but it makes sense, and it makes the property easy to distribute after death. It's always best to consult with an attorney about which estate planning tools make the most sense for your situation. Transferring asset titles to the trust is the part that can be really tricky and therefore expensive, but it makes it easy on beneficiaries at death, oftentimes avoiding complicated probate. An attorney may charge by the hour or a flat rate to create a trust. If you have a living trust, you may still want a pour over a will. This directs that the property that is not already in your trust must be put in your will at your death. So if you buy a car, anything before your death, and you haven't specifically included that in the trust you created, this catch-all directs whatever unnamed property to go into your trust. If someone dies without a will or trust, this is referred to as dying intestate. State law will determine where your property goes if you have not provided for it in a will or estate planning document. And I want to just pause for a moment and say the following, because this is an important point. If you do not create a will and you're no longer living, then the state will give you a will. So I ask of you, who knows better what you want to happen, you or the state? So that's probably the most important case for making up some kind of advanced planning document. It's my goal to inform you that you have a way to control beyond your life how you want things to go, even if you do not have a lot. If you have not created a will, typically the property will go to your spouse and children. If you have neither, it goes to other relatives like parents, siblings, nieces, nephews, and cousins. If someone has no surviving relatives, then your property goes to the state. If you don't own much by way of property, maybe you don't really care about having a will in place. However, remember that pets do count as property, and people often forget to make plans for them. Some property already has a designated beneficiary like life insurance policies or bank accounts. These must be changed to the company rather than through a will or other document. People and pe- People who at the end of their life or people who are going through intense treatment often need assistance in managing their financial affairs. A power of attorney for financial affairs is a legally binding document that you prepare or have prepared for you, where you choose a trusted person known as your agent to make financial decisions for you. This means they can manage your finances, they can dispose of your property or sell your property during your lifetime. You don't lose authority to manage your finances unless you become incapacitated or unable to make decisions for yourself. This is not the same as a power of attorney for healthcare or healthcare proxy. I'll discuss that shortly. But it's a good idea to talk to an estate planning attorney to name someone to make decisions for you. Should you need an extra hand managing your finances, or if you should become incapacitated, then you have someone named who will make financial decisions for you. This must be notarized or signed by 2 witnesses. Advanced healthcare directives are written instructions that state a person's wishes about the healthcare and treatment they want to receive if they're unable to make decisions for themselves. Advanced healthcare directives are intended to avoid unwanted care, reduce suffering, and ensure that a person's wishes are honored at the end of their life. For example, you can state your desires regarding life-sustaining or life-prolonging medical treatment or pain relief. In California, there are 4 parts to an advanced healthcare directive. You can find them online at caringinfo.org. Power of attorney for healthcare, otherwise known as an agent-patient advocate, instructions for your healthcare, organ donation, and primary physical identification. A living will, also called a directive to physicians or advance directive, is a document that lets people state their wishes for end-of-life medical care in case they become unable to communicate their decisions. It has no power after death. Now, let's recap and I'll leave some time for questions and we'll get out before the hour. Here's the 5 tips recap and just think about how much you've learned today. It is the patient's responsibility to understand their insurance coverage. Number 2, don't take no for an answer. Number 3, request accommodations before your work performance is affected. Number 4, you may be able to take time off and keep your job. And number 5, document your end-of-life wishes before it's necessary. So these are the 5 legal tips and the topics we covered today. And thank you so much for participating in this presentation. Please remember that if you have any questions that are specific to your situation, you can either call the CLRC or fill an intake form online and we will get back to you. And if you bear with me in just a moment, I'm going to stop the recording and then I'll be able to take some questions.